In Massachusetts, the Homestead Act is covered by Massachusetts General Laws, Chapter 188. And this language in this particular law allows people to declare an estate of homestead. In an estate of homestead, when you declare it, it gives a homeowner or someone that owns property, occupies that property as a principal residence, it gives them protections. Anyone can file a homestead as long as they own the property and they occupy it as a principal residence. Some people think that property is limited by age. And you could be 18 years old and you own a piece of property, you really should get a homestead on. It's a consumer protection issue. You're really protecting yourself against potential claims that can arise in day-to-day living. Homesteads are covered, they cover real estate, but not just a single-family home. If you own a two-family home and you occupy one of those residences as your principal residence, one of the units, you should file a homestead. The homestead has been extended in a number of areas where you must file the declaration of homestead at the Registry of Deeds. Here in Norfolk County, we cover 28 communities. For instance, people who have mobile homes. Now you should file a homestead. It's been extended to mobile homes. You should file or consider filing a declaration of homestead. People that have property in cooperatives can file declarations of homestead. The homestead, there was questions, but recently with new changes in the statute, people that have property in trust, the trustee can file a homestead. Again, there has to be representations that beneficiaries are occupying the property as their principal residence. Maybe it's just one of the beneficiaries is occupying the property as a principal residence. And under the new law, the declaration of homestead should be filed. The benefits of the property owner are it gives them protection. Many people have insurance and they get protected through their insurance policies. But sometimes people don't have as much insurance on the property as they would like. It's tough fiscal times, tough economic times. Sometimes people have no insurance on their properties. So what the homestead does, it's a declaration that gives people certain protections. When I first became Register of Deeds, the protection was $300,000. It was extended to $500,000, and that's the number that currently is in existence. And you can get $500,000 worth of protection against certain claims. And you might say, what are those claims? Well, sometimes people get themselves in trouble. They might have credit card debt. They might have other debt. They might have been in a bad car accident where there's a judgment against them or some other judgment. What the homestead does is, by declaring that homestead, it prevents creditors from using that home as a way to collect on any judgments or on specific debts. What it does is it puts a picket fence around the home so there's no forced sale of your home. There's no execution on your home. And when you think about it, the biggest asset most people have is the place they live in, their home. And you really should take steps to protect it. You could talk to attorneys, and I say, sometimes people joke. They say you talk to 10 different attorneys, you get 10 different opinions. But I'm willing to bet 9.9 out of 10 attorneys would counsel someone to get a homestead. And you may want to speak to an attorney about the benefits of getting a homestead or your particular situation. But it's really a right of the consumer that should be taken advantage of, that the protections are now $500,000. It should never replace homeowners insurance. Again, people really should seek their insurance agents and get insurance coverage. I recognize in the tough fiscal times we are, a lot of times people cut back on their insurances. But people should protect themselves, whether it's the homeowner's insurance, whether it's your car insurance, because that gives you protection. That should be your main source of protection is insurance, monies. Again, people can't afford sometimes on your car. Sometimes you have $250,000 worth of coverage, but in the tough economic times, people drop down their coverages to $50,000 or $20,000. That's when you really put your house at risk. So if you have to do that because of tough economic times, you really should put a homestead on. But no, a homestead is not a substitute for good insurance coverage. And that's something the homestead protections have been extended to. A homestead, if it's declared, protects the proceeds from the sale of a home for up to 1 year. And if your home somehow was destroyed by fire and there was a casualty loss, the proceeds from any casualty loss, the insurance proceeds, a declaration of homestead that was filed actually protects those proceeds under the new statute for 2 years. So again, you can see this trend towards extending protections to people, and that's even more reason, it's even more reason why you should get a homestead protection. But one of the changes in the law means that if you do nothing, you now get $125,000 worth of protection. It may be allocated if there were 2 owners, the $125,000 would get a portion. But that is good news for the consumer. A lot of people are busy. A lot of people, despite our outreach, aren't aware of the protections of the homestead and don't declare a homestead. So what the new law does, if you haven't done anything, you at least get $125,000. Prior to the law, you were out of luck. If you didn't declare a homestead, you had no protection. So under Chapter 188, Section 4, if you own a property and you have that as your principal residence, you get at least $125,000 worth of protection. But why wouldn't you take advantage of declaring a homestead like under the old law? You have to take affirmative steps to declare a homestead, and it's relatively simple to do. The homestead form is available online at www.norfolkdeeds.org. You can download a form, and all you need is to get the title reference. For those people that have registered land, that would be a certificate of title. That's through the land court. For those people that have recorded land, it's a book and page. You got a deed from somebody and it was recorded at a certain book and page. All you have to do is reference that book and page, and you may have inherited the property, and you could just reference the probate court filing and number that allowed you to inherit that property. And the document has to be notarized. One of the changes is if you own the property jointly with your wife or spouse, both spouses have to sign the document. Both spouses have to sign that document in front of a notary. So that's, some of the changes that have been made require more information. There's even information under the law where non-titled people who are living in the property have to be referenced in the document. For instance, one spouse might own the property individually, yet the other spouse whose name isn't on the deed is living at the property. So it gets a little tricky. There are little references like that, little nuances that have to be looked at, and that's why people should, maybe take the time to either look at them themselves or seek counsel. But the big thing to remember, most people own the property either individually or with their spouse, is that if you own it with the spouse, both of you have to declare the homestead, and both of you would take the time to sign it in front of a notary on one form and get it filed at the registry. Here in Norfolk County, the filing fee, again, which is set by the state legislature, is $36, and that's one of the lowest filing fees at the Registry of Deeds, and I think it's low for a reason. Consumers should take advantage of it. The state legislature also defines elderly people as being 62 years of age or older. If you fall into that category, you can declare a homestead as well. They call it an elderly homestead. Again, a lot of what we've talked about in the past applies to an elderly homestead. You need to get a title reference, whether it's a book and page if it's on the recorded side, a certificate of title reference if it's on the land court or registered land side, or a probate court number if you inherited the property. And again, it has to be notarized, and the filing fee is $36. Other interests in real estate are now covered, at least under the statute. Here in Norfolk County, we allowed these documents to be recorded because we thought people had a right to have their interests protected. But people who have property in trust can file a homestead. People that have a possessory interest in their property, some people deed their property to their children and reserve a life estate. We've seen and we've accepted, and the law accepts homesteads that cover that life estate. So any interest you have in that property that's your principal residence, the homestead law is really a law that you should take advantage of. It's a consumer protection law, and again, it doesn't protect you against everything. you have to pay your mortgage. If you don't pay your mortgage, the bank will foreclose. If you don't pay your taxes to your community, that community will foreclose and take the property and tax title. There may be judgments or orders from the probate court for spousal, support for not just alimony but more child support. Again, if you have a homestead on, that's not going to help you with those situations. You have to pay your taxes. You have to pay certain court orders. You have to pay the bank their money. But overall, the homestead does set up this almost a fence around your property, which will then protect you from a forced sale of your home. The biggest asset most people have of their homes. Take the time to protect it. Go to the Norfolk County Registry of Deeds website, www.norfolkdeeds.org, to get any information you want on the homestead, or call our customer service number. We have a customer service department that we are very proud to have established at 781-461-6101. When a property is sold, and again it's an arm's length transaction, traditionally that voided a homestead, and the law that just went into effect works on that if you sell your home, the homestead is terminated. But if you buy a new property and that property is your principal residence, you could put a new homestead on it. In the legislation, they've also taken steps to make clear when people refinance, they are not voiding their homestead. That was one of the issues we saw a lot. When people refinanced, there were actually clauses in the mortgage documents that in effect terminated the homestead. And again, that's something people may want to look at their past refinancing activity to see what language they signed, as well as when they filed old homesteads. But the new law that went into effect March 16th, 2011, is making clear that, even if there's language in a mortgage that says the homestead's terminated, it is not terminated. It is subordinated to that mortgage. In other words, that mortgage still can be acted upon, and the homestead doesn't nullify the rights of the bank or the lender in the mortgage to go and foreclose on the property, which is the state law anyway. But I think that is something that needed clarification, and the legislature responded with the new law to make clear that homesteads, even if the language in the mortgage said they were voided, aren't voided. So, but other than that, if you sell your property, the homestead runs with the land. So if you sell your property, the homestead's terminated. But most people, maybe you're going to move into a new home. Take the time to put a declaration of homestead when you move into that new home to make sure it's protected. I can't see any downside to getting a homestead. Seek counsel. I'd say most attorneys would counsel you to get a homestead. Unfortunately, people are in tough fiscal times right now, tough economic times. But you see a lot of people, even before they go into bankruptcy court, they're getting advice to file a homestead before they go into bankruptcy court. So there is no downside to filing a homestead. It is protecting the consumer. It is protecting your family. The biggest asset you have is your home. You don't want to do anything to lose that. And what the homestead does is it prevents a forced sale of your home, and that's the most important thing for the consumer, is to keep your home. We all get into troubles. There are people that have, in this tough economic times, have debts. You could have the misfortune of being in an accident. There is no downside to the homestead. And people think, oh, that's not going to happen to me. Certainly anything can happen to anybody, and the best thing you can do is, to protect your home, is to put a declaration of homestead. As I said, in my tenure as Registrar of Deeds, it went from a $300,000 protection to $500,000 protection. Who knows, in the future they may increase that protection, and it would be well worth the consumer's effort to go to the Registry of Deeds and get that homestead filed.